it was these prosecutors in this courtroom or whether or not it was another prosecutor, and it had been inadvertent. We're not claiming anybody did it on purpose. It was clearly left by the state of Florida in this courtroom. It clearly wasn't left by the defense firm here. We're not from here, nor would there be any reason for a defense attorney to have 2010 state of Florida state attorneys.
Well, unless you were asking to borrow one for some.
It's true, but since I have 2013 less, I probably would. So
the revised one, or there was a second 2013 one?
No, I don't know. It still works pretty good. So our belief is that this issue is caused by the state, inadvertently or otherwise. So the defense's request is that the court allow deliberations to continue. If there's a verdict of guilty in the case, we're going to request at that time that the jurors be questioned objectively, not about their deliberation process or their mental process in the deliberation, but whether they consulted the book and in what manner it was consulted, what portions, and by whom. And at that point, we would address the issue of whether it was appropriate to grant a defense mistrial after a verdict. Obviously, if there's a verdict in our favor, there would be a non-issue at that point. That's how we're requesting the court handle the issue. Oh, I would also note, I think, this is straightforward again. We probably won't get this out of here, too. There's looks like an evidence book. I don't know what the rest of the stuff we've got here, but
those are typically materials that are left there by one side or the other when divisions will utilize this courtroom for their regular everyday calendars and trials. I have one for the state, one for the public defender.
Well, that one's just property of the state of Florida, so I gave it back to them. I don't know what to do with the rest of the stuff. I'm just thinking the jurors come back into the room and watch it.
I think we'll all be more vigilant if it happens again. James, you can just hide those somewhere.
Give me up with them. All right, so that's how we request it be handled.
All right, so you're not asking the court for mistrial at this point?
We're not, Judge. We discussed it with our client. Our belief is that it will be handled after, like I said, an adverse verdict, but it is clear that we're not asking for mistrial. I know the court's going to want to conduct a colloquy. If the court is not inclined to take our position, to adopt our position, and is saying we want a mistrial now, the answer is no, we don't want it now. We'll still be making a request later for the guilty verdict, obviously. And also, as we discussed, the case law in Chambers talks about individual questioning of jurors about the use of the materials. We've also discussed this with Mr. Rivera. The defense's decision is to not request that be done at this time during deliberations. Our belief is that it should not be done during deliberations.
Okay. State your position.
Well, Judge, this is clearly a gotcha, I want my cake and eat it too position. You can't, that law does not allow that. If they want to mistrial, they want the jurors questioned first, which is normally the way we do it. You question the jurors first to see whether or not that book, which was inadvertently left here, and it's not by any of us. We don't have 2010 books anymore, unfortunately. It's a very old book. And we do not, we believe the jury, obviously, they're going to come watch the video, which is the only reason we're supposed to be in here. The video was set up. They'd all be sitting in the chairs looking. Nobody had any idea when it was forgotten. They certainly didn't be wandering around the courtroom, and that they would take anything back and ignore your Honor's instruction on that. So it's not really the state's fault. We want to make it the state's fault. It's not really the state's fault. It just happened. That things happen. They cannot have their cake and eat it too. They want the jurors colloquy to see whether or not they looked at it in that nature, what parts they looked at. They can do that now. That's what your Honor would need to do in order to determine whether or not the bringing of under the case law, the book into was prejudicial to the defendant. They can't sit back and wait. They want to wait. They can file whatever motions they want if there's a guilty verdict. However, I think the defendant has to understand, I do not believe the case law will support their ability to get a new trial based on this issue.
Well, the defendant doesn't need to understand Ms. Pearl's opinion of the case law, Judge. The defendant needs to understand he has the right to ask for this trial at this point. He has the right to ask the jury to be polled at this point on the issue or questioned by the court on the issue. And those are the issues. So he doesn't need to speak.
We're done speaking.
I'm still talking. I'm not being cut off by defense counsel. I just wanted to be clear that this will not be, the state will be vigorously, the law supports the state's position. They will not be allowed to use this later on saying that. He is taking his attorney's advice, which is what he should be taking his attorney's advice, but he should be not. The state's position will be, and maybe I'll be wrong, maybe I will be right, which is that he is waiving it now. And he can't come back later and say, oh, Judge, counsel was ineffective because they gave me bad advice. Well, he's going into this colloquy, which is what the court, we're asking the court to do, knowing that there's a possibility that his counsel's advice on this may not be correct. And it's a tactical decision by them to try to have their cake and eat it, which I hope. And if the defendant wants him questioned, the jurors question, it must be questioned now before they go any further. That's the state's position.
So the state is not asking for the jurors to be questioned on their behalf or to raise any issues of mistrial at this point.
Well, the state will not be asking for mistrial, because I think Robin knows that we put ourselves in a precarious position, which may be part of this tactical thing to try to force us to ask for mistrial, then we'll come back and fight on jeopardy. So we're not going to go down that game plan now.
If the court feels that they should be questioned, and the court should question them, we did ask that the court question them again, whether they followed your general instructions last night.
I'll ask them about whether or not they follow my nightly deal instructions that I give them. I will not question them directly about this issue. Any more from the defense?
Gotcha.
Okay.
The sarcastic tone and nasty is right on. It's like,
Judge, we don't want to go around with anyone about it. We simply want you to
We're done with that.
question the defendant about the fact that if the defense wants the jurors questioned now, they should do so. If the court believes in its discretion, in your discretion, that you should question them about what did they look at? Did they look at anything? What did they look at? And we could take it from there, then you should do that. And otherwise, just discuss it with the defendant and let him understand that that's a tactical decision that's being made now that may waive any future appellate issue.
we just think the question should be framed this way, Judge. Not just waiving the right to do it in the future, because we have a disagreement over what the law allows. Ms. Brill stated earlier, the law doesn't allow us to do it the way we request. The law doesn't, as we know from looking at the cases in chambers, doesn't address a situation where this is discovered during deliberations. All the cases were post-verdicts, because it was always, as the court pointed out, discovered after the verdict. So we don't know what the appellate courts think should be done when it's discovered in the middle of deliberation. So we think the question should be framed, do you realize you have a right to request a mistrial? We don't know if the court will rule on it, number one. And do you realize you have a right to request that these jurors be questioned on the issue now, at this point? Do you want to follow your attorney's advice and not make those requests at this time? And I think that's a fair way to ask them to make what they want on the record regarding Mr. Rivera's knowledge.
All right. Let me initially say that I think your request that you would like to wait and see what the jury does before you decide whether or not to ask for a mistrial. You're not asking for one question becomes, the attorney doesn't want to do that now, and I guess it's advised you not to do that now and wait, play it out, and see what the jury comes back with. And if it comes back bad, for you to ask the court at that point for a mistrial and to question the jurors at that point. I'm not inclined to do that, nor will I do that at this point, because I think that's not the appropriate procedure. And I think by not asking for it now, questioning, or the mistrial motion, you stand the possibility of having waived that right as an issue on appeal. If you were to lose, to waive the decision as to how to treat this issue as a issue of ineffective assistance of counsel in the event that you would lose this case and lose any appeal and filing a post-conviction motion saying that the reason you're in prison and got convicted is because your attorney misadvised you and was ineffective in representing you. You're aware of those scenarios. You had a chance to discuss this with your attorneys, correct? You had a chance to discuss the fact of asking for a mistrial now versus waiting, right?
Yes.
And you had a chance to ask about questioning the jurors now, right?
Yes.
Okay. And you heard them say they don't want to ask for a mistrial now. They don't want to question the jurors about the book at this point. They want to wait to see what happens with the jury. Right? You heard them ask that. Are you in agreement with that request by them?
Yes, I agree with.
Okay. Anything else from the state that you think I should be asking? No? Okay. Thank you. You can have a seat. Ralph, line up my jury.
Yes, Judge.
Research or investigation on your own as it may relate to some of the issues that you had during your deliberations. Did everyone comply with my rules last night?
Yes, sir.
Okay. Anything else we address before we send them back in for their continued deliberations?
No, sir.
All right, if you will step back into the jury room.
All right, ladies and gentlemen, let me check the door inside to make sure it's open and locked for you.
And there's nothing else in that room.
Okay, ladies and
But
gentlemen.
before you send them in, Ron,
Yes,
go look the room over.
okay, Judge.
We left over gremlins from Halloween down there. All clear?
I checked the room before, but yes, Judge, it is all clear.
All right.
Ladies and gentlemen,
Was it hot in there?
sometimes it's hot and sometimes you don't like that. That's right.
You'll have to wait till I get back at 1 o'clock.
Judge, had arrangements were made for them for lunch? Is there
Yes.
any discussion about that?
Yeah, Ralph is taking the lunch orders for Oklahoma like we did yesterday.